Hi, my name is Chaudhry Shah Mohammed, and today I'm here to give a presentation on company law. There is a statement given to me, and under the light of that statement, I have to answer three questions regarding the relevant law and the structure. The first question that needs consideration here is what is corporation? The word corporation is derived from a Latin word corpus, which means body or person. The main characteristic of a corporation is that it is a separate legal entity from its owners. Corporations enjoy most of the rights and responsibilities that individuals possess. They can enter the contracts, loan and borrow, sue and be sued, own assets and pay less. Some refer to it as a legal person. The second question which arises here is what is corporate personality? The concept of a separate corporate personality is the fact that is stated by the law. Corporate personality is recognized as a legal entity which is separate from its members. The rights and obligations of an entity has its own obligations and legal rights which are distinguished from its owners. According to the case Salomon versus Salomon Company Limited, property owned by the company belongs to it and not its members. Now I would like to answer the first question, which is part of my presentation: circumstances piercing the corporate veil. The phrase piercing the veil of corporation means that uncertain circumstances, the courts can look through the company to the identity of the shareholders. The following are the circumstances which lead to the piercing of the corporate veil. According to the common law, there are like four circumstances in which the corporate veil may be pierced. First one is fraud, shame, facade. Second one is single economic unit. Third one is national emergency or agency. And the fourth one is interest of justice. Similarly, according to statute section 213 of the Insolvency Act 1986 and section 214 of the Insolvency Act 1986. Now I would like to shed the light on the first circumstance in which the corporate veil may be pierced, which is fraud, shame, facade. The veil will be lifted only where special circumstances exist, indicating that it is a more facade situation concealing the true facts. The first case which I would like to quote here is John versus Lippman, 1962, and in this case it was held that the veil was lifted in order to prevent the seller of a house evading specific performance. An order of specific performance was granted against him, and the company to transfer the property to the buyer. The second case which I would like to refer here is Guilford Motor Company Limited versus Horn, 1933. In this case, it was held that the company could be restrained from competition, as the previous employer had set it up to evade his own legal obligations. An injunction was granted against him and the company. Another case which I would like to refer here is Truster versus Smallbone. In this case, it was held that the veil was lifted in order to make Smallbone jointly and severely liable for the sums received by the Intercom. Another circumstance in which the corporate veil may be pierced is single economic unit. Although each company within a group is a separate legal identity, there have been a number of cases where the courts have lifted the veil between a holding company and its various subsidiaries. The case I would like to refer here is DHN Food Distributors versus London Borough of Tower Hamlets, 1976. In this case, it was held that Lord Denning stated that the corporate veil could be lifted, that the company were in reality a group and should be treated as one single economic unit. Another case which I would like to refer here is Wolfson versus Strathclyde, 1979. In this case, it was held that corporate veil could only be lifted in this way in circumstances where the company is a facade. So the company was a facade in those circumstances and the corporate veil was lifted. The next circumstance in which the corporate veil may be lifted is national emergency and agency. In times of war, it is illegal to trade with the enemy. It may be possible to lift the veil of the incorporation. In the case Daimler versus Continental Tire and Rubber Company 1916, it was held that the defendant, a UK incorporated company, was owned by 5 individuals and a company incorporated in Germany. Only one individual was British and he held only one share. Similarly, it was held that the claimant need not to discharge the debt to the defendants since the effective control of the latter was in enemy's hands. Another circumstance in which the corporate veil could be pierced is interest of justice, and the first case I would like to refer here is Adams versus Cape Industries 1990. In this case, it was held that it was unsuccessfully argued that the veil should be lifted between the companies so as to enable the judgment against Cape. The court said there was no special circumstances indicating that CPC was a facade for Cape, like the situation in John versus Lipman, the previous case which I mentioned. Similarly, under Section 213 of Insolvency Act 1986, at the time, according to this act, at the time that the company is going into liquidation, if the liquidator becomes aware that directors or shareholders knowingly deal in fraud, they can be held personally responsible under civil law for debts and other liabilities of the company. Under Section 214 of Insolvency Act 1986, if a company in insolvency proceedings is found to have traded when there is no reasonable prospect of avoiding insolvent liquidation, its directors may be held liable under civil law for wrongful trading. Again, a court may order such directors to make a contribution to the company's assets. Now, I would like to answer the second question of my presentation, which is corporate personality is a settled law. First, it is very important to shed a light on the origin of separate legal entities or corporate personality. The separate legal personality concept was first recognized by courts in the case Salomon versus Salomon, which was decided in 1897. According to this case, once a company is incorporated, it has a separate legal existence to the shareholders of the company. The company must be treated like any other independent person with its rights and liabilities appropriate to itself. The principle of separate legal personality was confirmed in the case Lee versus Lee Airframing Limited 1960. In this case, it was held that although Mr. Lee was the majority shareholder and sole working director of the company, he and the company were separate legal persons despite the fact that he was the sole working director of the company. Now I would like to shed the light on veil of incorporation. The corporate veil exists to distinguish a company as a legal person separate from its shareholders. Incorporation veils members from outsiders' view and it limits the personal liability of corporate directors, officers, and employees for actions taken by the business. Lifting or piercing the veil. It is sometimes necessary by law to look at who the owners of the company are. This is referred to as lifting the veil. A judicial act of imposing personal liability on otherwise immune corporate officers, directors and shareholders from the corporation's wrongful acts. The company is a separate legal entity, for example, separate from its shareholders, the part owners and its directors, the managers. It can be seen in the case, as I quoted before, Salomon versus Salomon Company Limited 1897, in which it was held that Salomon as shareholder and director had no personal liability to creditors and he could be repaid in priority. This preserved the concept of separate legal personality and limited liability in law. Another case which I would like to quote here is Makora versus Northern Life Insurance 1925. In this case, it was held that in this case, let's just shed the lights on facts of this case, in which Mr. M owned a forest. He formed a company in which he beneficially owned all the shares and sold his forest to it. However, he continued to maintain an insurance policy on the forest in his own name. It was held in this case that he could not claim on the policy since the property damaged belonged to the company and not him, and as shareholder, he had no insurable interest in the forest. There are a number of consequences of being a separate legal entity, and I would like to shed light on a few of the main points. The first one is limited liability. A company is liable for its own debts. Like in this scenario, the company would be liable for its own debts. A company enters into contracts in its own name and can sue and be sued in its own name. A company owns its own property. And the next point I would like to quote here is a company has perpetual succession irrespective of the fate of the shareholders. The management of the company is separated from its ownership. A company is subject to the requirements of the Companies Act 2006. Where a company suffers an injury, it is the company itself that must take the appropriate action. It can be observed in the following case: Foss versus Harbottle, 1843. In this case, it was held that the court dismissed the claim and held that when a company is wronged by its directors, it is only the company that has standing to sue. Every company has its own separate legal personality and identity separate to the identity of directors, shareholders, subsidiary, and parent companies. Shareholder liability is limited to the amount to be paid up on their shares. Shareholders of companies are not liable for the debts and liabilities of those companies. Shareholders have rights and responsibilities arising from the company's constitutional documents and any other relevant governance arrangements. There are fundamental principles of English law dating back to the decision of the House of Lords in Salomon versus Salomon, 1897. Similarly, Section 16 of the Companies Act 2006 sets out the effect of registration of a company. A body corporate is capable of exercising all the functions of an incorporated company and has its own existence as an entity. A director exercising his duties and responsibilities on appropriate basis is not liable personally for the acts and omissions of the company. When a company goes into liquidation, shareholders are only liable to the nominal amount of the shares according to the Section 74 2D of the Insolvency Act 1986. The distinction is important and was considered by the Supreme Court in Prest versus Petrodol Resources Limited in the context of recasting the principle. There are two distinct principles. The first one is concealment principle and the evasion principle. Now I would like to answer the third question, which is the impact of corporate personality on multinational corporate activities. The company, which is a separate legal entity, insulates the individuals participating in the business from personal liability which may arise as a result of doing business. In this way, a company can have several benefits. Some of them are: it can generate revenue in the foreign country which is owned by the company. It incurs the expenses which are payable by the company. It attracts legal liability to pay taxes to taxation authorities, and typically pays tax at lower rates than individuals. The business owners and directors are protected from liability other than in limited circumstances, which essentially involve some sort of fraudulent conduct. Now I would like to shed the light on impact of corporate personality on joint ventures. When two or more independent business, the separate legal persons may wish to cooperate to start a special project, which is referred as special purpose vehicles, as they have a specific purpose for formations. They can have several benefits. They are jointly owned by the founding companies. They may make profits which are owned by the joint venture company. They can buy and own assets. They can buy and lease property. They can license intellectual property rights such as software. They can have their own customers and suppliers. They can pay expenses, taxes, employees, and consultants. They can return profits to the founding companies in agreed percentages, and are sold off when successful. Other than that, they can isolate the liabilities to the joint venture, and they can be made to fail gracefully and be dissolved without affecting the founding companies. Now I would like to discuss the foreign separate legal entities. English law also recognizes legal entities which are accepted as legal entities in their country of formation. The case law which I would like to refer here is Bumper Development versus Commissioner 1991, in which it was held that the Hindu temple was a separate legal entity. It had legal personality under the law of the state where it was created, and that was merely in the premises of India. Now, I would like to make a conclusion here. It is hard to deny that there exists within the English law a doctrine of piercing the corporate veil. However, its actual limits remain very unclear and very uncertain. It is well established that courts should only have the power to pierce the veil when all other remedies have been exhausted or failed. Those circumstances would obviously be very rare. The majority of cases dealing with the issue recognize the principle rather than applying it. There is yet to be enough of an agreement amongst members of the court on the underlying principle of the doctrine, and therefore it seems development in this area of law will continue to be very slow, and it would be very incremental. So thank you so much. That was my presentation, and I hope you liked it.